Hey there, welcome back to yet another episode in the journey of demystifying the Patents Act. Over the course of last few videos, we answered various questions such as who, when, why, pertaining to the provisions of compulsory licensing. While doing so, we kept using the terms reasonable requirement and the terms and conditions associated with a license, but we never got to discuss them in details. In this video, we will discuss various parameters which can help us to decide if the reasonable requirement of public is met or not. Section 84.7 of the Patents Act provides us with a few checkpoints to decide if the reasonable requirement of the public is met or not. Let's go over them one by one, starting with the use case where the patentee is refusing to grant a license or is granting a license but with unfair terms and conditions. Now, because of these unfair trade and conditions, activities pertaining to the existing trade, industry, or businesses are getting hindered, or development with regards to such trade, industry, or business is getting impacted, or new trade, industry, or businesses are not getting established because of the terms and conditions associated with the license. Similarly, commercial activities pertaining to other businesses are also getting hampered because of the unfair terms and conditions associated with the license. Additionally, because of such terms and conditions, demand with respect to the patented article is not met to an adequate extent under reasonable terms. Similarly, market for export for such patented article is either not supported or worst, not even established. So the development of such scenarios could be considered as a clear case of reasonable requirement of public is not met. Sticking to the terms and conditions associated with the license, let's discuss another use case where, because of the terms and conditions associated with a license, activities such as manufacturing, sale, or use of any other material or product which was not even protected by this patent are getting impacted. Basically, some unfair or anti-competitive clauses would have been inserted in the license stating that such and such product cannot be used if you take license from us. So such clauses can also lead to a situation where it could be ascertained that the reasonable requirements are not met. Similarly, other unfair terms and conditions could be, I give you license in this patent, you give an exclusive license back in your patent, exclusive grant back. That's an unfair ask. Or, while giving a license to you in this patent, I demand that you sign an agreement that you will never challenge the validity of my patent. Again, an unfair ask. Or worst, I give you a coercive package licensing where I bundle other products or licenses along with this particular license. So such unfair terms and conditions are not allowed in a license, and such can lead to establishing a fact that the reasonable requirement of public is not met. Moving on to another scenario where the invention is not worked in India at a commercial scale to the fullest extent possible. Now, one reason for the invention not to be worked in India could be the fact that somebody is importing the patented article to India. Now, who that somebody could be? It could be the patentee, or it could be a person authorized by the patentee, or it could be any other person who may not be authorized by the patentee, but the patentee is not taking any action against such infringing activities. And such importation is hindering the invention to be worked in India. So these are the parameters that can help us to decide whether the reasonable requirement of public is met or not.